Okay. All right. When you can, make an attempt to sign in. No rush. Let's see. All right. Well, we're down to at least 6 registered. One person dropped the class. That person I don't think ever came. Okay. All right. We're down to 6. Okay. Let's start off by bridging our class from last class to this class with a series of questions. Okay. Try inadvertently. Okay. All right. Our discussion of enumerated powers turns in large part on what year we are in. At various points, the court has taken various approaches to interpreting the implied powers of Congress. Now, whenever I say discussing what are the enumerated powers of Congress, you have to always keep 2 things in mind. Both the Commerce Clause and the Necessary and Proper Clause. You will be tempted to only say Commerce Clause. If you do that, you will not be complete in your answer. You need to consider both elements of the Constitution. What I want to do to test you on the development of this doctrine is to ask you the same question in different years. And this question always gives students a bit of a hard time, but I do this deliberately in the 4th or 5th class to get you thinking in this framework of how the court's doctrine has changed. Aha, we have a book. Excellent. No plastic. Very good. Okay, so here's the question they want you to answer. Congress enacts a law to regulate the wages of workers at coal mines that ship coal across state lines. Congress finds that moral conditions in the mines are low and that safety conditions are poor. Is this statute constitutional? Yes or no? And I want you to think about this at 6 different junctures. This might sound insane, but I promise you it'll make sense in a few minutes. So let's actually take a poll. And okay, start poll. Open cloud. Okay. All right, so first off, let's do 1842. And the reason why I picked 1842, in case you couldn't tell, that was the year Prigg versus Pennsylvania was decided. Right? Prigg was in 1842. Okay? All right, let's start. Yes, is it constitutional? B, no, it's not constitutional in 1842. Okay. All right, very good. I think I got all 5. Okay, very good. Let's see what we got. Okay, so Lindsay, I'll start with you. What do you think the answer is here?
Yes.
Okay, tell me why.
Because in Prigg, it was held that if it was convenient for them, on Prigg, if it was convenient for them to regulate commerce through the necessary and proper clause, then it was proper and it was constitutional.
Okay, Chelsea, what do you think?
I also said yes.
Okay. Oh man, I can do everyone. What do you think?
I picked yes.
John? Tyler? I'm sorry. It says John on the thing.
Yeah, I believe I picked B, not intentionally. Sorry about that. Yeah, I mean, I would agree. Necessary means to an end primarily.
Okay. Suresh, what do you think? Well, 2 of you put B, so I'll just assume that was an error. Okay. I think the correct answer is A. I think the answer is it's constitutional. And the reason why is that Justice Story's opinion in Prigg was extremely deferential in how it reviewed Congress's powers. Right? I think Lindsay's word convenient. I think that's a good word. So long as Congress's exercise of some power is a convenient way to regulate interstate commerce, then Congress can do it. So here, the mine is actually shipping coal across state lines, right? But what's being regulated is not the shipment of the coal. What Congress is regulating instead are the local wages that are being paid. Make sure you see the difference, right? Even though the business itself involves shipping coal, Congress is regulating the local activity of the wages being paid, citing things like health and safety and moral conditions. Okay? Everyone with me? All right, now let's try the next one, 1869. And I'll give you a hint. That was the year that DeWitt was decided. I'll give you a little hint to help you out. Okay, let's try this one now. Question number 2. Oh, this is so much easier with 5 people. Oh, I shouldn't show the results while the thing's going. In my larger classes, people actually change the results before I hit the stop button when they see what other people put. It's embarrassing. So it doesn't count. It's fine. All right, another few seconds. All right, I think I got everyone. Okay. So we got, okay, perfect, 5. Everyone got it right. It's unconstitutional. Okay? And let me explain the reason why. In DeWitt, this was an opinion by Chief Justice Chase, right? This was about the selling of oil. Chase explains that what they're trying to regulate is a local condition, right? The selling of oil, the wages. These are not matters for the federal government. And Chief Justice Chase would write that this is too remote from interstate commerce, right? That's the word he used, remote, right? Distant, too much separation. And I think that it's important to recognize that Chief Justice Chase didn't exactly see eye to eye with Justice Story and Prigg. And there's a gap between what the court held in Prigg about implied powers and what 27 years later the court held in DeWitt. Okay, any questions on that part? So far, so good, guys. Very good. All right, let's try number 3, and I'll give you a hint. Number 3 is E.C. Knight. Okay, let's try this one. Okay, got all 5. Very good. Let's see what we got. Perfect. Okay. Now this one I think is a little bit trickier, but let's just tease this out a bit. So Audrey, what was the test in E.C. Knight? This is what we reviewed from last class. What was the test that the court put forward in E.C. Knight to discuss when can Congress regulate local activity and when can they not?
I think it was called the Direct Effects test.
Very good. Right. The court drew a distinction between a direct versus an indirect effect on interstate commerce. Right? A direct versus an indirect test in direct versus indirect effect in interstate commerce. If this local activity directly affected interstate commerce, right, then Congress could regulate it. If the effect was indirect, they couldn't. Now, Tyler, let me ask you a follow-up question, right? Our fact pattern here says that the moral conditions, morale is low in the mines, poor safety conditions. Couldn't you argue that having these poor safety conditions does have a direct effect on interstate commerce? That is, if they're not proper ventilation, maybe they're not mining the coal correctly, maybe there's a lot of contamination, maybe people might die and might increase the cost. I mean, couldn't you say that the health and safety conditions here are, in fact, do have a direct effect on interstate commerce?
You could, and I think it would be further justified in 1903.
Oh, we're going to get there in 2 seconds. We'll get there in a few seconds. That's the next question. But just stick with me here. But how do you draw the line between direct and indirect?
Is it part of the actual the commerce process? Transport, railroads, common carriers, as in along the same lines as not too remote as previously described.
Yeah, you're doing a good job, but the opinion doesn't give a lot of specificity. Strosh, let me ask you a follow-up question. If Congress is concerned about low morale and safety conditions. And they raise the minimum wage. Does that actually address the problem they're concerned about?
No.
Well, does it do it directly or maybe indirectly?
I mean, it could be argued that indirectly they are affecting it by giving them better wages. But if we were looking at it directly, there's no correlation between the.
Okay, so this is what we call the means and scrutiny, right? Is the thing that Congress is doing, is it actually going to achieve the end they're trying to achieve, right? Does raising the wage actually make people have more morale? Probably. Does it increase safety? Probably not. In fact, if you raise wages, they probably spend less money on safety. I think that's a fair trade. If Congress was actually concerned about safety conditions, why don't they just regulate the safety conditions in the mine, put inspectors, right? In other words, they're not actually concerned about the safety. They're just trying to use this to raise the wages. So as you think about these sorts of questions, always keep the means and scrutiny, where the court here would say, this is not really about health and safety. You're actually just trying to regulate local wages, right? You don't actually care how safety conditions affect interstate commerce. If you did, you'd regulate the health and safety, right? Ensure that there's actually a safe process to extract coal. You're going around it to go after local wage conditions, and that is why I think it's indirect, right? This goes back to Tyler's point. I think the reason why this would be indirect, and I may have the question, so what do I know, is precisely because they're not regulating the thing that directly affects commerce. They're regulating something that might indirectly affect the commerce interstate. Does that make sense? Okay.
I think that's where I get confused, is
Yeah.
how they figure out the indirect part. I'm trying to think of a synonym.
It's a oh God, do I say proximate cause, or are you still scarred by that? Right?
Yeah.
Right? I mean, is there an intervening cause, right? In other words, if I want to improve safety conditions, and I say that safety conditions affect interstate commerce, then let me regulate safety conditions, right? Do the thing that actually will achieve the goal. Don't just do something around it that might incidentally increase it. Because look, I think if you raise the wages, you'll probably spend less money on safety, which is probably, fixed costs. You figure it out. Okay, does that make sense? Let's try the next one, number 4. And I think Tyler was hinting at this one. This is champion right here. Okay, I'll start it up. Number 4. Okay. All right. We'll go to Lindsay. So what do you think here?
On champion, it's constitutional.
Okay. Well, now, oh, good. You all nailed it. Very good. Why do you think this one's constitutional?
On champion, the court held that they could regulate and even prohibit local activities if it was an appropriate end or means to the end. And they, in the case of the lottery tickets, it was because it was a moral issue.
Okay, very good. Yeah. Champion had this sort of weird holding where they suggested that Congress has the power to regulate activities that might affect public morals. And it wasn't really clear what the effect of public morals was on interstate commerce, but so it was this carve-out. And to this day, to today, champion is still cited for Congress's power to regulate moral issues. It's not fully developed. Okay? All right, very good. You guys are doing very well. All right, let's try this next one. 1935 is Schechter Poultry. Okay, this is new stuff, these last two, but I want to get you thinking about them anyway. The sick chicken case, exactly. That's what it's called, the sick chicken case. Okay. All right, I think I got everyone, all 5, okay. All right, Chelsea, what do you think here?
I said it wouldn't be constitutional.
It's unconstitutional. Why do you say that?
I'm trying to remember that down.
It's second. Just go around. Yeah.
I'm sorry, I can't remember.
Okay, that's fine. Archie, what do you think?
Didn't they say that since it only affects inside the states, Congress shouldn't be allowed to deal with it or make laws that regulate?
Yeah. Yeah.
Since regulating wages.
Yes. Very good. Very good. Tyler, anything?
Wages, hours, and slaughter, that's still pre-commerce.
Yeah. Okay. Very good. Soros, you want to add something?
They both say.
Okay. Fair point. Okay. I think the correct answer here is, I think y'all got it right. I think it's unconstitutional. Oh, I should make sure I put my notes correct. And that one was. And I think the reason why is this brings back the direct effect test from E.C. Knight, or basically there's an argument that commerce comes after the manufacture, right? That commerce, in this case, commerce comes after the coal mining. The things that come before the shipment cannot be regulated by the federal government. And also here in Schechter Poultry, which we'll cover at some length, the court reads necessary and proper in a much more narrow fashion. All right, last one, which is number 6, and this is NLRB, right? Jones and Laughlin versus NLRB Steel. I'm sorry, NLRB versus Jones and Laughlin Steel. I flipped it in my head. Okay. Okay, almost there. All right, we got 5. You should have to leave these on for a minute. Okay. And I think you all got this correct. It would be constitutional by 37. I think, Lindsay, you're next. Or sure, I think you get off in the pass in the last one. Why would this one be constitutional, sir?
I believe, if I remember correctly, it was because of what affecting commerce was.
Very good. It became known as a substantial effects test, right? Contrast, right? E.C. Knight was a direct effect test, and then 1937 became substantial effects, right? Serge, what's the substantial effects test? How's that work?
Go back to just read it too.
I'll come back, Lindsay.
So a substantial effect doesn't necessarily have to be a direct effect. It can be an indirect
Instead of saying
effect.
it, use a noun. What's it in your sentence?
If whatever they're trying to regulate.
The local activity.
The local activity.
Right.
If it has a substantial
Very good.
effect. It doesn't have
A
to be
substantial
direct
effect on what?
Interstate commerce.
There it is. Just spell it out, right? If a local activity has a substantial effect on interstate commerce, then Congress can regulate that local activity, right? As a general matter, Congress cannot regulate local activity. They can't. However, if that local activity then has a substantial effect on interstate commerce, Congress can then regulate it. We'll do this in much more depth in a few minutes, but I just want to give you the preview. All right, and now stay tuned for next class, which I won't ask you about today, but I will ask you about mañana. The year is 1996, when I think most of you were alive. Maybe not. I keep getting older and students say the same age. It's the funniest thing, but it does happen. I think this year the 1Ls will have been born in 96. What year were you born?
87?
No, sorry.
Oh.
91.
91, yeah.
I'm 94.
Yeah, I'm 84.
Yeah.
It's okay. But I think this year, because if you're born in 96 and you're 21, 22, yeah, I think we'll probably have some 98s this year also. We'll get to the point where after the 2000s, just if you weren't alive in the 2000, that's it. Can't vote. That's it. You're done. Never. Okay. All right. So any questions on that? All right. Go back and just think this through after class, and as you're putting together your outline and notes, try to think of how the answer fluctuates. And you have in the timeline in the video, which I think will help you. We're almost done with the videos. We're so close. You will not have. I don't think you'll have all of them by the time your semester finishes. I think you'll have, actually you might, because you're not doing First Amendment. I think you'll have all the videos will be done by the time you cover the cases. We're so close. We're so close. It's painful. Almost there. All right, let's start. And let's start the first case, which is Schechter Poultry Corporation versus United States, 1935. I think Chelsea might be next. All right, want to give me the facts, please, in Schechter Poultry?
Yes. So the defendants own the Schechter Poultry,
Uh-huh.
and
What was their business?
they slaughtered them.
Yeah, and just one note, it was a kosher slaughterhouse. If you don't know, kosher is a ritual Jewish slaughter. And in particular, this is a fun fact, the word shecht is a Yiddish word for to kill or to slaughter an animal. So their family name, most of the people actually got their last name based on their family business. Their family name was actually butcher, right? Imagine like you're a carpenter and your last name is Carpenter, right? Or your last name is Baker and you're a baker. Here, the last name of the Schechter brothers, there were these brothers in Brooklyn, and their last name was basically butcher in Yiddish. Yiddish is like a local dialect, a Germanic Hebrew dialect that was very common among Jewish-speaking people. Okay, all right, go on.
They purchased their live poultry
Mhm.
from the Washington Market, New York City, or terminals in Philadelphia.
Very good.
They would buy the poultry for slaughter and resell it.
Okay, so let's just be careful. They bought their poultry outside of New York.
Yes.
Then they brought, I say schlepped, the poultry back to New York. And then they slaughtered everything in Brooklyn,
Yes.
right? And then where'd they sell their stuff?
In Brooklyn.
Very good. Okay, go on.
And there was a live poultry code under Section 3.
Okay, we'll get to the poultry code in a minute. So I just want to just want to focus on this for a minute, right? The actual act that was being regulated was not the purchasing of the live chickens. It was not the transport of the live chickens. Chelsea, what was the actual act that the poultry codes regulated?
Sorry.
It's okay.
Well, I know it fixed the workday hours, and taking particular poultry to the
Very good. So it regulated the sale and the slaughter of the dead chickens, right? Again, this was not about the raising of the livestock. It was not about the transportation of the livestock. It was not about the moving them across state lines. The case only concerned the slaughter and the sale. All of this stuff actually crossing state lines happened before this regulation came into effect. This regulation was not concerned about any activity that actually crossed state line. It was only concerned about local activity after the poultry came to their demise. Now, Audrey, let me just focus on this point for a minute. Who enacted these poultry codes?
Wasn't it the Congress gave the president the power to do that?
Okay. And how did the poultry codes actually come into being?
The president signed it.
Can the president make laws? Oh,
Yes.
well, maybe. This case, Schechter Poultry, is very significant, not just for its ruling on the Commerce Clause. That stuff was important. But it also, I don't use the word affects, but also implicates something called the non-delegation doctrine. The non-delegation doctrine. What is the non-delegation doctrine? It's a rule that says that the legislative power belongs to Congress, right? The legislative power, the power to make laws, belongs to Congress. And Congress cannot give away that power to the executive, right? Congress cannot give the president the power to make laws, for such a law would violate the separation of powers. Here, Congress gave president the power to enact labor codes with virtually no guidance, right? And in fact, as it turned out, the president basically let local unions and various labor groups write these rules. Okay? the court in Schechter Poultry, this is not in your book, because I'm not expecting you to know it, but I'm giving you additional stuff to enrich your education. The court in Schechter Poultry explained that the legislative power cannot be given away in this fashion, that Congress has to give guidance to the president of how laws ought to be enforced, that Congress cannot give the president a blank check to enact whatever laws it sees fit. So the court found that the entire enforcement of these poultry codes was a violation of the non-delegation doctrine. But it also considered whether Congress would have the power to even regulate local wages, right? That's the part I actually want you to learn. And then the question here is not just about the Commerce Clause, of course, it's also about the Necessary and Proper Clause. Critically, this law did not regulate interstate commerce. It did not. It only regulated economic activity. And the question was whether Congress could then could regulate the local activity, that is how the chickens were slaughtered and how the chickens were sold. Everyone understand the case? All right, let me take a step back, give you some more facts. Under the rules of kosher slaughter, the rules are very stringent. You can't kill any chicken. If the chicken was sick, for example, it's not kosher. You can't eat it, right? If it was injured, maybe its wing was broken or its neck was injured or there was a cut on its neck, you have to discard the chicken. You couldn't eat it. The Schechter brothers were kosher butchers. And so what did they do? They would give people the option of which chicken to buy. And they would let people say, okay, this chicken, no, this chicken's sick, I'm not going to buy it, right? The poultry codes made that a crime. The poultry codes had a thing called straight killing, which basically means you got whatever you got. You couldn't pick and choose which bird you wanted. In many regards, this was a free exercise case, right? That the government made it a crime for these butchers to, and their customers, to engage in this ritual religious procedure, this slaughtering procedure, and it made it a crime. Right, so these labor codes are not just about imposing a minimum wage. Right? I don't think they really cared about that so much. Maybe they did, but the problem was the sick chicken part. And in fact, this case became known as a sick chicken case because they were prohibited from selling sick chickens. Right, they could get rid of them. Yeah, Audrey.
Why did the president or the other people making laws? Why did they care about making this law? Is that I'm confused.
Oh, don't make me cynical. Okay, fine. I try not to editorialize in class. I try really hard, but you're making me. These were labor codes that were largely written by organized labor. Most labor laws are designed to drive up the cost of labor to increase wages. And it's right when you increase the cost of producing goods, eventually the cost is passed on to the consumer. Right? So eventually someone pays for it. But at least in the short term, it provides benefits to those working. So for example, if you have a policy that if you throw out chickens, right, that might be seen wasteful. And it might be seen like it's not a good use of resources. So this was a policy designed to incorporate a specific economic vision of how labor should be organized. Same for the minimum wage, et cetera. The Roosevelt administration was very keen on letting organized labor and industry basically write the rules that regulate them. And this happened in quite a bit, where they would basically negotiate of how these labor codes should be existing. And these weren't just a union negotiates with an employer. It was basically the law. And the failure to comply with this law could be a felony. These guys were charged with a crime. They actually could have gone to jail for selling the chickens. Right? And that was a very prominent aspect of the Roosevelt administration's approach to economic reform, that to get the United States out of the New Deal, the government needed more of a role in how businesses transacted their selling of the chickens. That's the short answer. They were a disaster. And in fact, when we discuss the National Recovery Act, right, that was the law at issue in the Schechter Poultry case. This law basically tried to dictate, I don't use that word lightly, how every business transacts almost every aspect of its affairs. Schechter Poultry, we'll get to the holding in a minute, was a 9-0 case. This wasn't 5-4. This wasn't like the conservatives and the liberals were on different pages. Even Justice Louis Brandeis, who was the progressive cause lawyer, joined the majority in Schechter Poultry, which I think this vote was a testament to how far the NRA went. But the NRA is National Recovery Act, not National Rifle Association. But this case is a testament to how far the NRA went in pushing the bounds of the federal government's control over local business. Not even the states had tried to regulate businesses at this level of granularity. I mean, you had a code, one code for Brooklyn, another code for Manhattan, another code for Queens. You had these little labor boards that basically made the code by which their competitors performed at every juncture. It was ambitious, and a few other adjectives perhaps. Sorry, my George Mason economics is creeping out. I try not to, but occasionally I can't help it. I really try hard not to. This topic, when we get to the New Deal, it's very, very eager. Okay, that make a little more sense? Mm-hmm. All right, so let's actually walk through the court's opinion in Schechter Poultry. So the court finds that Congress lacked the power to enact the NRA. They said it was a bridge too far. The court explains that this regulation is not of the slaughtering. I'm sorry, that we don't have interstate commerce. The slaughtering was not interstate commerce. The sales of the chickens were not interstate commerce. Even if the transportation that came before the sale and slaughtering was interstate commerce, the act that Congress was regulating was not. And that's a key point. In this case, you can't only look at what the entire economic picture is. You have to look at what Congress, in fact, did. Had Congress tried to regulate the shipment of chickens from Pennsylvania to New York, I think that case comes out very differently. But that's not what they tried to do. Okay? The law allowed President Roosevelt to regulate any transaction affecting interstate commerce. And here the court reaffirms the direct effect test. This is a test from E.C. Knight. Okay? It's possible that slaughtering the chickens in this fashion has an indirect effect in interstate commerce, right? If people now are able to buy chickens at a substandard price, maybe they'll need to buy fewer chickens in the marketplace, right? So maybe the fact that the Schechter brothers are charging a lower price might have some sort of indirect effect. But indirect effect is not enough. And then Chief Justice Hughes, again, who's no conservative, he was a progressive. Chief Justice Hughes said, if we accept the government's theory, quote, there would be virtually no limit to the federal power. And for all purposes, we should have a completely centralized government. Okay? There's always this concern, if we let Congress do this, then what's the limit, right? Where do we draw the line? What's the limiting principle? Okay? All right. So any questions on Schechter Poultry? I'm sorry. Someone raise your hand? Okay. So President Roosevelt lost Schechter Poultry, but this is basically one of the last cases that he would lose. We'll talk a lot more about 1937 when we do the due process clause, but I'll give you a little bit of a preview here. In the early 1930s, President Hoover appointed two justices. He appointed Chief Justice Hughes, and he appointed Justice Sanford. I'm sorry, Sanford died. He appointed Justice Roberts, replaced Justice Sanford. Even though President Hoover was a Republican, he was a progressive in many regards. As a result of the appointments by President Hoover, the court moved to the left. And the conservative nominees began to be replaced more by progressive nominees. By the time you get to 1936-37, you now had basically 4 conservatives, 4 progressives, and 1 guy kind of in the middle, Chief Justice Roberts. And by the time you get to 37, Justice Roberts begins to more or less vote with the liberal bloc of the court. And then after 37, the conservatives start to retire. And President Roosevelt, by the time he was done, made 9 appointments to the Supreme Court. He made 9 appointments. So basically, everyone on the court was of his choosing. by the time he got to the end of his fourth term. So between 35, when you have Schechter Poultry, and the next case 37, Jones and Laughlin Steele, we had a constitutional revolution. There's not much other way to describe it. We had a sea change. And it's not that the meaning of the Constitution changed. Rather, you had justices of different philosophies interpreting that document. And one of the first major cases, not the first, but one of the first major cases that reflected this sea change was NLRB versus Jones and Laughlin Steele. I always said Laughlin, but Randy says Laughlin. I don't know which one's right. Think of like Lori Loughlin from the college scandal, the Full House one, right? I don't know. Okay. And this case involves the National Labor Relations Act. And just to give you some background, the National Labor Relations Act created a government agency called the National Labor Relations Board, the NLRB. The NLRB has 5 members. 3 members are appointed by the president's party, and then 2 members are appointed by the opposite party. So at the time, there were 3 Democratic appointees to the board and 2 Republican appointees to the board. The NLRB had a lot of power. They had an enforcement arm that if any business didn't comply with the Labor Act, they could then basically sue them in court. They also had courts where they could judge whether these agencies or these companies were complying with labor law. They also have the power to make rules, right? They can basically issue regulations that companies were not bound by. We'll discuss these so-called administrative agencies later. But in many regards, these agencies combined all 3 branches. They had both executive, legislative, and judicial power. They're neither fish nor fowl. Often these agencies are called the 4th branch of government because they don't really fit anywhere else. But this case wasn't a challenge to the entire existence of the federal agency so much as it was a challenge to the National Labor Relations Act, the actual statute. And this statute gave the federal government the power to punish, quote, unfair labor practices affecting commerce. Unfair labor practices affecting commerce. Now, when you see the word affecting, you have to immediately think necessary and proper. Right? Whenever you see the word affect or effect or affecting, you think necessary and proper. You think McCulloch. You think implied powers, right? The court will not always say necessary and proper, but you know the correct answer. It's necessary and proper. All right? Okay. Any questions on that? Who's next? Who's next? Yeah. Oh, yeah, you're next. Sure. Okay, Fabian, you want to give me the facts, please, in NLRB versus Jones and Laughlin Steele?
Okay, so first of all, once I had enacted the NLRA, National Labor Relations Act.
Good.
Which,
Ooh, no.
so the act gave the NLRB the power to punish unfair labor practices
Very good.
affecting commerce. So Jones and Laughlin Steel Corporation was prosecuted under this for unfair practices against their workers, and pretty much their argument, the corporation's argument was that the NRLA was an attempt to regulate all industry and invading the powers of the state over local concerns.
Very good. Very good. Okay, thank you. Again, this case wasn't about whether Congress could regulate the actual shipment of steel, right? That was not this case. The labor violation at issue was not the shipping of steel. It was the actual treatment of workers in their facilities, which was not interstate. So the question here is whether Congress can then regulate that local activity. Now, Sarosh, under the test in E.C. Knight, the direct effect test, what's the answer to this question?
Under E.C. Knight, it would be no.
Yeah. Yeah. This is easy, right? Why is the answer no under E.C. Knight?
Because it's not directly affecting interstate commerce.
Yeah, the effect is indirect. right? Maybe the treatment of local workers can affect the prices in the marketplace. Maybe not. I don't know. We also have the case Hammer versus Dagenhart, which was a child labor tax case, where the court says that the Congress can't go after local activity. It's a province of the states, right? Commerce comes after the shipment of the steel. It's not the manufacture of the steel itself. But here the court comes out the other way, right? And the court doesn't quite go all the way in, right? The court says that the federal government can't regulate all labor relations, but they can regulate, quote, what may be deemed to burden or obstruct that commerce. Right? That Congress may regulate what may be deemed to burden or obstruct that commerce. This is Justice Harlan's dissent in E.C. Knight, right? Where Harlan says that whatever impediments to interstate commerce there are, Congress can use its necessary and proper clause powers to remove those impediments, to remove those burdens. So here we see Justice Harlan's dissent gaining some traction. And then he gives a test. The opinion was by Chief Justice Hughes, the Hoover appointee. He wrote, by the way, Hughes was the same guy who struck down the NRA in Schechter Poultry 2 years earlier. So this was Hughes coming at this. Hughes says that Congress can regulate local activity that has, quote, such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions. Let me just read that again. He says, Congress can regulate local activity that has a close and substantial relation, that's basically saying substantial effect, to interstate commerce, and the control is essential or appropriate. What does that sound like? Essential or appropriate? Bingo. Bingo. Necessary. And using Marshall's words for necessary, appropriate, useful, convenient, right? To protect that commerce from burden. So in other words, if it's useful to Congress, if it's appropriate for Congress to regulate local activity to prevent certain burdens on interstate commerce, they can do it. Right, so there's interstate commerce, you have steel going back and forth. If Congress can prevent burdens on that interstate shipment by regulating local wages, and that's an appropriate means, they can do it. So you see the shifting, right? It's not about whether there's a direct effect. It's whether there's a substantial effect, right? Where if all these workers are there, and maybe if they're being treated poorly, they make substandard steel, and they ship crappy steel to another state, that's a burden on interstate commerce. Therefore, Congress can regulate it as a means to eliminate those burdens. It's not regulating local wages because they want to regulate local wages. It's regulating local wages to prevent burdens on interstate commerce. Now, no one actually believes that. That's not what they're doing. They're regulating local wages to regulate local wages. But the court will uphold it under a deferential, necessary, and proper clause analysis because there's a substantial relation, a substantial effect. The means, regulating wages, has a relationship with the ends, eliminating burdens. That's all you need. Does it make sense to regulate wages to protect interstate commerce? Sure. Okay, that's enough. It does not have to be a direct effect. And here they basically kill the test in E.C. Knight. And E.C. Knight is no longer good law. All right. Yeah, Audrey.
I have a simple question. If everyone can tell me this correctly. But okay, I get confused on whenever it's talking about regulating local wages. Because I think of wages as in
Wages are local. If you're working in my coal mine or my steel mill and I hand you a paycheck, no one's crossed state lines. You've done all of your work here.
That's what I'm thinking. But why
Don't think of a direct deposit coming through, a bank transfer, right? Back in the day, if you worked in a coal mine and they handed your paycheck at the end of the day, that was not interstate commerce, and no one thought it was. It was a local activity.
I have two questions. So you said the means was regulating wages and the ends was what?
Eliminating the burdens on interstate commerce. right? In other words, is there a substantial relationship between higher wages and transporting safer steel? Maybe, probably, yeah, and that's enough. The courts don't have to demand precision. It's a deferential test.
And my other question was, so you're saying that this is not necessarily about like Congress wanting to regulate wages to protect interstate commerce. So is it another case where it's like they're trying to really do something else?
Yeah. I mean, they want to regulate local wages because they want to regulate local wages.
To just like.
Because they want to help people have higher wages. Yeah, that's exactly why they're doing it. In other words, if they were actually concerned about the quality of steel being shipped across state lines, they could pass a law saying standards for what steel must look like when you ship it across state lines. Right? They say, okay, all steel must meet a certain quality. We'll inspect it, right? If they were actually concerned about the shipment, maybe they have a law concerning the tractor trailers that transport them. They have to have certain types of safety requirements, right? Mm-hmm. There are lots of ways they could actually benefit interstate commerce without regulating the wages locally. It's indirect. But the court won't play that logic game. They're not going to demand that level of precision. And Sarosh, and then I'll come back to Audrey. Is your hand up?
No.
Okay, back to you.
Oh, yeah, I guess I'm trying to talk it through, so I was just trying to see if they're regulating wages and they were trying to like reason that paying their workers more or paying their workers less would be a burden.
Well, the thinking is, but let me put it this way. It doesn't really matter if it makes sense. The purpose of this sort of substantial effects test is let the Democratic branches figure it out. We will uphold this so long as there's some basis to do so. Right? In E.C. Knight, the court said, no, this is bogus, right? Commerce comes after manufacture. You're not actually regulating the manufacture. Think of Hammer versus Dagenhart with the child labor. They said, look, you're not actually regulating the goods. You're regulating who can work there, right? If you want to ban the shipment, you can do that, but you can't actually regulate the wages themselves. Okay. Now, I want to put a caveat here. In Jones and Laughlin Steel, the court didn't go all in, right? They didn't put their entire feet in the water, so to speak, right? They said that we can't obliterate the distinction between what is national and what is local, right? They recognize, okay, but there's some line, right? We don't know what that line is, but we can't destroy that line. We can't obliterate it. It's a question of degree. Okay? Okay, so they didn't actually overrule E.C. Knight yet. They came awfully close. That came a little bit later, right? But they basically are saying there's this line between direct and indirect. We're not going to tell you what it is, and we will probably never get there, but this line, I think, still kind of exists. Yeah, Vivian.
Yeah, that's what I thought was really interesting when I saw that Justice Hughes put his limiting principle on the document. What does that even mean when
they're always drawing that line because they're afraid of a holding that gives the federal government unlimited power. So they always draw some line, whatever that line is. Yeah. Some of the justices would say, forget it, I don't want to draw a line, do whatever you want. But the majority always puts some line in there that it does exist, that some effect is too indirect and too remote to qualify.
Does this have anything to do with today we have a minimum wage law?
Oh, we have a minimum wage law? We do.
Does that have to do with interstate commerce?
Yes. Yeah, the federal minimum wage law is part of what's called the Fair Labor Standards Act, the FLSA. And that law is premised on the effect that local wages have on interstate commerce. Almost every law that exists today involving labor is premised on the Commerce Clause and the Necessary and Proper Clause. We'll do Katzenbach and Ollie's Barbecue in a few minutes. Federal anti-discrimination laws regulate local activity that might have an effect on interstate commerce. If local discrimination affects interstate commerce, Congress can then regulate it.
So
Yeah.
I have a question. So, like, for instance, the Jones and Laughlin coal mine, it's a local business.
Steel, yeah.
Steel, sorry.
Mm-hmm.
So it could theoretically be argued that it's not, interstate commerce. They had a fairly decent case to make it all the way to the Supreme Court. But what about a company like Microsoft or Dell or Chevron and Shell?
Well, again, so let's be precise here, right? The question isn't whether Congress can regulate a company. It's whether they can regulate specific activities, right? If there was a train company in the 1930s who transported from one state to another, I think one of the other plaintiffs here was actually a bus company, right? I think it was actually Greyhound. No one argued that Congress can't regulate Greyhound because they literally drive from state to state, right? That's their business. But here the activity was making steel. A steel mill is in one place, doesn't move, stationary, right? Doesn't go anywhere. The workers at a steel mill, they don't travel. They go to one place. They work in their steel mill. And the question is whether Congress can regulate that precise activity. Make sense? All right, other questions in Jones and Laughlin Steel. Very important case, 1937. All right, let's move on to the next case. Next case is United States versus Darby 41. This is 4 years later. By this point, all the conservatives had basically retired. Roosevelt had a majority of the Supreme Court appointed. And at this point, the federal government begins to even further expand their powers. Who's next? I think, Lindsay, I think you might be next. I think. Are you next first? I can't remember. I think Fabian was, okay, yeah, you're next. Okay, sorry. All right. Suresh, you want to give me the facts, please, in the United States against Darby?
The U.S. v. Darby, I had read this case, but I kind of like skimmed over it.
That's not a good answer.
No, I know.
Okay.
It goes back to the Fair Labor Standard Act about, God, exactly.
Okay.
I don't want to waste time.
Okay. Be prepared, please. Okay. All right. It's if you're not preparing this class, I'll call you every 3 minutes. All right, Lindsay, you wanna give me the facts in Darby, please?
So this is a case where there were lumberjacks.
Lumberjacks, yeah.
That there was an issue with their wages under the Fair Labor Standards.
That was Audrey's question 2 minutes ago, right? That's the FLSA, exactly.
And they were stating that it wasn't interstate commerce because it was wages, but then the court held that because the wood was shipped across the states, that the lumberjacks' wages did have a substantial effect on interstate commerce.
Very good. Thank you. The reason why Darby is in your book is that it expands upon Jones and Laughlin Steel. Okay? It expands upon Jones and Laughlin Steel. Now, what does it not do? The court does not expand the definition of commerce. And that's an important point that most law students get wrong, right? The New Deal cases, when I say New Deal, I mean during the Roosevelt era, 1930s and 40s. The New Deal cases did not expand the meaning of commerce. We are stuck with John Marshall's opinion in Gibbons. What is commerce? Intercourse, trade, exchange, sale, barter, right? That's what commerce is. The court did not hold that cutting down trees is commerce. They did not hold that. Instead, what they held, I think Lindsay said it correctly a moment ago, is that the local activity of cutting down trees has a substantial effect in interstate commerce. And because of that substantial effect, Congress can then regulate that local activity of chopping down trees. Okay? This is based on McCulloch and necessary and proper. And the court says it very clearly. It doesn't matter what Congress's true motivations were. It doesn't matter if Congress intended to regulate local activity. It makes no difference. The court says, quote, whatever their motive and purpose, regulations of commerce which do not infringe some constitutional provision are within Congress's powers. It makes no difference. So long as what's happening is local and has a substantial effect on interstate commerce, Congress can regulate it. Darby is what ushered in this sort of substantial effects test. Everyone with me? Yeah, Fabian.
So how does it tie into McCulloch? I'm sorry, I remember when I was reading it, I was super confused.
McCulloch is about the necessary and proper clause, right?
Yeah.
And it gave weight to the meaning of necessary, right? What is an appropriate means for Congress to regulate commerce? Here what the court's saying is it's appropriate for Congress to regulate local activities, local lumberjacks, as a means to regulate how the wood is ultimately shipped across state lines, right? It's an appropriate means to an end, right? It's appropriate to regulate local lumberjacks as a means to ensure safe wood is transported across state lines. It doesn't even matter what the actual answer is, right? Once you say it's appropriate, at that point, nothing matters. It really doesn't.
I think where you talked about the video, I think it says what clause from the McCulloch case does
You
this.
talk about the limiting principle.
Exactly. Yeah.
I immediately thought necessary and proper, but
That's
it's
right.
for commerce.
Well,
right?
it's both, right? They can use their power under the necessary and proper clause as a means to regulate interstate commerce. Say it one more time, right? Local activity has a substantial effect on interstate commerce. Therefore, Congress can regulate that local activity as a means to regulate interstate commerce, right? You always have to go back and forth. You start with the local activity. Does it have a substantial effect on interstate commerce? Yes. If so, then Congress can regulate that local activity under its necessary and proper clause. Congress did not say that chopping down trees was was commerce. They did not say that. Most law students think that's what they said. Commerce, the meaning is pretty fixed. It hasn't changed. What's changed is how broad. You went from a direct effect to a substantial effect. Is there a direct effect between local wage conditions and the quality of lumber shipped? No. Is it indirect? Yeah, it's indirect. But basically, indirect now becomes substantial, right? Yeah, proximate cause. If you want to say proximate cause, that I don't want to bring in torts. It's a sore topic for many students. I don't want to bring that back. I had a terrible torts experience at my worst grade in law school. I got a C+ in torts. It was not fun. True in fact. I bombed that exam. Didn't hurt me though. I got a B+ in ConLaw. How about that? Yeah, it's true. I survived. I had the last laugh. It's okay. It was a multiple choice exam, and I'm terrible multiple choice. I'm really bad. All right, this is up here. Oh, did any of you go to the? It's this weekend, right? The Langdell. Okay, very good. All right. So, any question about Darby so far? Okay. Then the court has this line. The court says, "The 10th Amendment states but a truism that all that is retained." that all is retained which has not been surrendered. The 10th Amendment is a truism that all that is retained which has not been surrendered. What the heck does that mean, Audrey? A truism. What the heck's a truism?
I'm trying to go back to the video notes because
I know they're in the video, so I'm asking you. That's why you got to do more than watch them.
Wait, ask me it again.
What's a truism? I'm asking you in general. What does the word truism mean? Let's start a little bit easier. What's a truism?
Truism, I would think something that's true.
Yeah, good. But why is it a truism? What about it? What does the ism add to the end of that word?
It adds. I'm not intelligent enough for this question.
Oh God! Don't say that. No, you're not allowed to say that in my class. You're all very bright. Don't say that.
You just kind of add a social aspect to it.
Okay, that's actually very good. No, I think that's actually very good. The idea of a truism is something that's so obviously true that everyone knows it, right? It's like, duh, or like, of course it's true. Or if you want to use more Jeffersonian language, it's self-evident, right? It's so obvious, it doesn't even need to be said. It's a truism. And the court says, the 10th Amendment, see, the reason why I'm doing this is I didn't know what truism meant when I was in law school. And my professor just said, oh, it's a truism. I was like, what the hell's a truism? So I always highlight points that I at least didn't know, because if I didn't know it, that means that you didn't know it either. What?
Me answering wrong actually helps me.
A truism, right? So it's so obvious, right? So the 10th Amendment states a truism. What's a truism? All is retained which has not been surrendered. All has been retained which has not been surrendered. Okay, Tyler, what's he getting at there?
that as long as we're concerned about what this means for, potentially an unlimited government, unless the act or Congress or this holding had gotten to the point where they specifically restrict the states in an enumerated way, it's something the state should not be concerned about. The police power, the rights inherent, unless otherwise specifically told, they still have them.
So again, all is retained which has not been surrendered. What does surrendered mean in that sentence? Who's surrendering? Are we giving up? Hands up? I mean, who's surrendering? Who surrendered?
I mean, would a better word be commandeered?
No, surrendered is a good word. What does surrendered mean in this context?
Given up.
Okay, who gave up what?
The states, in terms of their
Gave up what to whom?
ability to regulate interstate activity.
And who they give it up to?
Federal government.
Okay, now we're in business, right? All is retained, that is, we keep everything that has not been surrendered. In other words, the states have all the powers unless they gave it up. Right? The states have all of their police powers unless they gave it up. And what the court's saying here is, you surrendered it. You surrendered this power, so you can't now whine about it. But did they surrender it? They surrendered the power to regulate interstate commerce. Did the states surrender the power to regulate local activity that has a substantial effect in interstate commerce? No, they didn't. This court basically made it up in Darby and Jones and Laughlin. But this became the defining understanding of the 10th Amendment for much of the 20th century. I think probably still is, right? And just go to the 10th Amendment for a bit. It's in your little pocket constitution. We'll just read it for a moment. Okay, you can look on. That's fine. The 10th Amendment says, the power is not delegated to the United States. I think I have it up here also if you don't have it. Oh, I don't. I don't have it up here. I'm sorry. I thought I did. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively. That's basically what the truism bit's about, right? If the states haven't surrendered a power to Congress, then the states retain that power, right? If the state did surrender it, then Congress has that power, right? The power is not delegated. In other words, the power is not surrendered, are reserved to the states. If the states didn't surrender their power, then the states keep the power, right? So I mean, the truism bit isn't actually that crazy, right? It's actually not wrong. I think it's actually a correct description of the 10th Amendment. I think where the Darby case goes overboard is where they simply say, aha, the states surrendered a power to regulate local activity that has a substantial effect in interstate commerce. I think that's where the court goes overboard. But the truism bit used to make me very mad, but it doesn't make me mad anymore. Now it's basically, I think, summarizing 10th Amendment in a way to confuse the hell out of law students. And it's been doing that now for about 70 years. Yeah, Audrey?
How do the states, not just in this case, but in general, how would they give up their power?
When did the states surrender their power, Audrey? It was a very specific moment. Happened a long time ago.
This is something we've already talked about.
When did they surrender their powers? Hmm?
Last time it happened was in 1959.
No, not 1959, much earlier. This case was 1941, my God.
No, not a particular state giving up its power.
What power? Oh, I guess whenever they created the enumerated powers.
And when did that happen?
In 1781.
80. No.
Whenever it was drafted. 87, whenever it was ratified. Am I wrong?
When was the Constitution ratified? What year? 1780.
7.
The Constitution was drafted in 1787. It was ratified in?
9.
Bingo. And if you don't remember it, it's in your Constitution. The exam is a completely open book. You go to, at the end of Article 7, I don't know what page it's in your book.
So it was ratified in
1789.
89.
Yep.
It was drafted in 87.
Yep. Exactly. They surrendered their Constitution by, they surrendered these powers by joining the federal Constitution. By adopting the Constitution, they surrendered. They delegated some of their powers to the central government. They kept everything else, but they gave up some of their powers, and now they can't complain about it 200 years later. And you know what? The people in those states who want local control, too bad, because they gave it up as well. Right, that's why the 10th Amendment reserved to the states or the people. Who's complaining here? It's not the states. It's a steel company. It's Darby. It's a labor worker. It's a lumberjack. The local people saying, let my state regulate labor conditions. Don't do it for me. And the court says, nuh-uh. Your state gave up that power 200 years ago. Get lost.
Good question on the 10th Amendment clause 2 is not prohibited by it to the state. What would be an example of that?
We talked about them. Bill of Attainder, for example. Right, Article 1, Section, I think it's 10, lists a number of things that states can't do. For example, states cannot enact bills of attainder. Right? States cannot make ex post facto laws. States cannot impair the obligations of contracts. States can't grant titles of nobility. States can't enter into treaties. Right? States can't keep ships of war. Right? States can't coin their own money. There are lots of things states can't do. They're listed in Article 1, Section 10. But everything else they can, right? Now, that was true at the time the Constitution was ratified. We'll do later in the semester the 13th, the 14th, and 15th Amendments, which put additional limits on the states. States can't deprive due process of law. They can't violate the protection of law. They can't impose restrictions on the right to vote based on race. There are things states can't do. And those are prohibitions that exist today. Okay. Someone just on YouTube said, states can't issue letters of marque and reprisal. Thank you very much. People actually watch my videos and send me comments. It's kind of fun. You think you're the only ones watching? No, you're not. Okay. I've had situations where I'm asking a question, my students will know it, and I get it on freaking YouTube that people watching it know the answer. It's actually embarrassing, South Texas. Okay. All right. Anything else on Darby? All right. So basically, Darby, I think, overruled Hammer versus Dagenhart, and it does so expressly. Right? Hammer said that Congress can't regulate local activity under the pretense of regulating national stuff. Darby says, screw that. Hammer's gone. And the police power really has no role. Right? The state's police power has no role to decide the scope of Congress's implied powers. Okay. Any other questions on Darby? All right, let's go on to the last case. One of my favorite cases to teach. No, you don't like it?
I don't like this judge. I don't think.
You don't like
Actually, it's the first time.
Justice Jackson?
Yeah, I guess it's the first time I read his opinion.
Oh, Justice Jackson was a great judge. This is not one of his better opinions, but I'm a Jackson fan. We'll talk about Jackson later when we do the executive power, I think next week. Okay, who's next? I can't remember. Did you do this case?
Yes.
You read Wickard, the facts? Okay, give me the facts on Wickard, please.
Basically, Wilburn is a local farmer that has, I believe, he had like 11.1 acres.
Mm-hmm.
And he went ahead and started selling on 23 acres of land, like with some wheat. And at the time,
Wheat, not weed, just
yeah, wheat. Yes.
Okay, that'd be a lot of weed.
You make your bread out of.
Yeah. Yeah.
And basically, he was charged for an excess of, I believe, 239 bushels of wheat, and it was like 49 cents per bushel, so it came out to like $117.11. And he said he shouldn't be. He said, because we were talking about the Commerce Clause, he's like, I'm doing local stuff, I shouldn't be affected by this, so I'm not going to pay.
Is it just commerce?
No, there was.
What do you always have to do?
It was necessary.
Very good. I'm not criticizing you, but just get in a habit of always saying commerce and necessary and proper. It's both cases. Wickard I don't even think Wickard mentions necessary and proper clause. Doesn't even say it, but it's there. It's sort of lurking in the background. Okay, very good. Thank you. So earlier, I think Audrey asked me why were they trying to regulate the conditions in which chickens were sold, and this was based on the economic policy of the day, which was how to get us out of the Great Depression is to have control over food. The Agricultural Adjustment Act at issue in Wickard was one such idea. Here's the plan. We have hunger, right? We have starvation. How do we improve that? We need to increase the wages of farmers. Okay. How do we improve the conditions of farmers? We increase the price of food. And how do we increase the price of food? We limit how much farmers can grow. It was insanity. It was insanity. You literally were telling farmers don't grow too much because food's too cheap. Right? We need food to be more expensive so farmers get more money, and that way they grow more, but you have to limit how much they grow. It's again, this is not an economics class. I will get off my hobby horse, but it's just, this case, more than any other, when I tell non-lawyers the facts, I'm like, what they do? They were telling them not to grow too much food because they wanted to make food more expensive so people have more food. This is basically a kickback to farmers, right? If you were a farmer, imagine this, the government says, okay, don't grow as much and you'll get higher prices. And we will force your competitors to also not grow as much. That way they can't undercut your market. That was the plan. Yeah, Tyler?
We still do that, correct?
Of course we do.
Subsidies?
Of course we do. And there was actually a case at the Supreme Court about 3 years ago involving raisins.
Yeah.
Did you learn about that case?
Yeah, yeah.
Base-
Guilty. I'm with A&M, so.
Oh, you're an Aggie. Of course you know about it. Yeah. But there's basically a federal policy where raisin farmers were required to turn over a certain quantity of raisins every year, which were then shipped overseas to help keep the prices high.
How is this law?
Ask Justice Jackson. Justice Jackson's a good judge. This is not my favorite opinion of his, but he's a very one of the best writers in the Supreme Court history. Very good writer. This is not one of his better opinions, I don't think. Okay, so that was the idea. So it'd be great, right, if all the farmers limit their output to these quotas, then they keep the prices low and they can just have more money for farmers. But what happens if you sell too much? So we have Roscoe Filburn, right? He was a farmer. And he said, screw this, right? I'm going to grow some more. Now, I will ask my Aggie friend to maybe back this up, but was the amount of wheat he was growing even conceivable to be used by himself and his farm?
That's the thing. I didn't think that the regulations on the amount was abnormal at all. I thought, I mean, to me, it's like if the government says you can grow this much marijuana and you grow 9,000 times that and say that you're not dealing it, that's essentially the amount that this guy had with 239 bushels.
So this wasn't for himself and his animals and his farm and stuff. He was selling it.
Absolutely.
Yeah, I think every year there's an Aggie in the class who raises his hand, makes the same point, I swear. It's like, it's automatic. So I appreciate you making that point. And his livestock, right? I think everyone would agree that he was selling this stuff on the marketplace. But the court decides to actually limit its analysis to the facts in the record. They considered whether to send it back down to the lower court and say, okay, how much wheat is this guy growing? Is this actually conceivably being used locally? No, it was being shipped around. Okay, but the court decided to take the case as it was for a reason. They wanted to give the federal government a broad power. And this was a perfect case. If Congress could regulate locally grown wheat that never leaves the guy's farm, then they can regulate just about any sort of activity. Again, let me say it one more time. If the court upholds this exercise of power, they can uphold anything else. Had they said, well, he in fact is shipping wheat across state lines, so it's okay, that's Darby, right? That's no different than Darby and Jones and Laughlin. They want to go beyond Jones and Laughlin and Darby to actually uphold even local activity may have an effect on interstate commerce. But they did it in a very specific way, right? In a very specific way. Lindsay, did Mr. Filburn's wheat, assuming it was for livestock and no one else, did Mr. Filburn's wheat by itself have a substantial effect on interstate commerce?
No.
It did not. That's right. But, ... What did the court say there?
The court held that there's an aggregation
Bingo.
principle, that even though Mr. Filburn's wheat was trivial by itself, aggregation of all the locally consumed or grown wheat brings it into the scope that Congress can regulate it.
Perfect answer, right? Perfect answer. The court here, Justice Jackson, advanced what's known as the aggregation principle. Nothing with Aggies. It's too easy. The aggregation principle means you add up, right? When you add up all of the locally grown wheat, you add it up. And if you consider all of the locally grown wheat nationwide, that locally grown wheat has a substantial effect in interstate commerce. Why? By buying local wheat, you don't have to buy it from the marketplace. In other words, if everyone in Ohio sells their wheat locally, then you won't have to buy any wheat from Nebraska. And that's a burden on commerce. It obstructs interstate commerce. And therefore, to eliminate that obstruction, Congress can then prohibit this locally grown wheat by banning growing wheat over the quota. Right? This is the substantial effects test, right? One second. It goes like this. If local activity in the aggregate has a substantial effect on interstate commerce, then Congress can regulate the local activity. Right? What's the big change from Jones and Laughlin to Darby to Wickard? It's the aggregation principle. Okay. Oh, did you raise your hand up?
No, this is me thinking, but
Sure, go.
it's starting to all like make sense now.
Good.
But
Good.
am I supposed to look at this in a good way or in a bad way?
You can look at it however you want. Look at however you want. I'm not here to judge.
Is it still good law?
It's still good law. Wickard is still, and it gets worse.
But it makes more sense now that you say it out loud. But
Yeah, that's why I'm here.
I don't hate it as much as I did.
Well,
At first I was like, that's not fair. It's just this one guy in his own state. It's local, but now I see.
Everyone starts breaking the rules, and the entire federal program falls apart. Yes, Roche.
So would this be the case that finally overturned Knight?
Yeah, I don't know if the court ever expressly said we're overruling Knight. I don't think they ever did, but I mean, this is pretty close to killing E.C. Knight. Because if this case is right, then E.C. Knight has to be wrong. Right? So the court says, even though Filburn's own contribution to the demand for wheat may be trivial by itself, this fact was not enough to remove him from the scope of federal regulations. Here's the key quote. Filburn's contribution, taken together with that of many others similarly situated, is far from trivial. Right? So there's some small effect from Filburn, but if there were 1,000 Filburns or 1,000,000 Filburns, then they all have their effects aggregated, and the effect becomes then substantial. As a result, Congress has the power to enact the Agricultural Adjustment Act and regulate that local wheat. Okay. All right. Questions on Wickard? Yeah, Tyler.
Forgive me, I'm, to the definition of something, one of the portions where Justice Jackson seemed to be struggling with the holding and writing the opinion, it referred to, they went one direction, it would be a jurisdictional Rubicon.
Yeah.
What was that implication?
Oh, you don't like the word Rubicon. Maybe we should change that. Do we use the word Rubicon in the book?
Yes.
Is it in the case book or is it in the...
It's capitalized, so I'm
Is that in the textbook or the summary book?
the textbook, sir.
Okay, I'm going to remove that word. Oh, God. Thank you. Remove Rubicon. Okay, so the expression of the Rubicon refers to a famous river. It's not really important if you know that, but Julius Caesar crossed that river. And it was not high noon, but pretty close to it. And that was considered a very momentous change in a victory for battle, basically, right? It was like a boundary marker. So when Caesar crossed the Rubicon, it was like a huge change. What that expression is getting at is Justice Jackson's opinion, had he gone the full distance, right, would have basically eliminated night, would have said, it doesn't matter if it's national or local, the feds can do whatever they want. So at least here they said there is some difference between local and national, but virtually everything's national. Not everything, but just virtually everything. So it left a little bit of daylight, a little bit of room of what Congress cannot regulate. In other words, there's still a limiting principle. Congress can regulate like 99% of stuff, but they can't regulate that 1%. There's still something Congress can't touch. Had Jackson gone the full Monty, so to speak, it would have been 100%. And then night would have been overruled altogether. But I'm going to kill the word Rubicon. We don't need it.
Is it possible that it's not your word, but rather Professor Cushman's words?
Did we not use it? Where is it?
It's on page.
Oh, is it not from a quote?
239.
I wouldn't use that word.
Yeah, it's on page.
Is in the Cushman excerpt?
Yes.
Oh, okay, then I can't change it. Damn it. Okay. You know what? Then I'll add a note of what Rubicon is. I only came on this casebook in the 3rd edition, which the edition you have. I put so much stuff to change, and Randy's going to murder me when he sees the next round of editions. He's going to kill me. We love each other. We fight a lot. If you notice in the book, there are lots of Latin words with little brackets of what they mean. You're welcome. Because you're not going to look it up. I know you're not. And so if I just give you the definition there, you have it. Yeah, there's a lot of changes. It's like bleeding the entire document with red. We get along well. We do. We fight over words at length. But thank you for pointing that out to me. I appreciate it. And I will make a note, Tyler, about that for next edition. The 4th edition, which you don't have, but it's consider paying it forward to your future South Texas classmates. All right. Anything else on Darby or Wickard or Jones and Laughlin Steel? Okay. After Wickard was decided, at that juncture, the Supreme Court would go nearly 6 decades before finding a law that actually is beyond Congress's powers. And had you gone to law school in the 1960s or 70s or 80s or 90s, your professor would have basically told you there is no limit and the federal government can do whatever it wants. That answer would change in 1996 with the United States against Lopez. That's your reading for, I think, tomorrow. But let's first cover a couple cases from the 1960s. These are cases decided by the Warren Court. Chief Justice Warren was appointed in 1953, check me the year, I think it's 53, by President Eisenhower. And this was a very significant period in the Supreme Court. It was during this time that both Congress, the executive branch, and the Supreme Court were in many regards aligned for the promotion of civil rights. And this period is often called the Second Reconstruction. We'll do the 14th Amendment cases from the Warren Court in the second half of the semester. In this half, we're going to be talking only about the federal powers cases. And particularly, Congress enacted an important law called the Civil Rights Act of 1964. Did anyone see the movie The Green Book? No? Heard about it. Okay. I think it's doing Best Picture or something, or won some big award. I don't watch movie shows. During the 1950s and 60s, it was very dangerous to travel throughout parts of this country as an African American. It was. In fact, a book was published called The Green Book that said, here are safe places that you can travel. Hotels, restaurants, gas stations, right? Where if you're traveling in certain states, here's where you can stay. And indeed, I've looked it up in Houston. There were quite a number of places that were listed in this book that you can actually come here and be safe. Congress tried to eliminate that problem by enacting the Civil Rights Act of 1964. This law said that in places of public accommodation, the businesses cannot discriminate against customers on the basis of race. What is a public accommodation? It's a common carrier. Hotels, trains, restaurants, certain types of stores. It wasn't everything. It was a pretty broad definition. but it was a large, theaters, for example, but it was a fairly large number of institutions. Now, Congress, when they enacted this law, relied primarily on the Commerce Clause and the Necessary and Proper Clause, primarily, not entirely. I want to pause here and give you a little bit of a preview for the second half of the semester. Now, you may think, wait a minute, Josh. I learned about the Civil War, and after the Civil War, we enacted the 14th Amendment. And the 14th Amendment has the Equal Protection Clause, right? And I learned that it violates equal protection to discriminate on the basis of race. So why can't Congress rely on the 14th Amendment to prohibit discrimination in these common carriers? And the answer is that word, state. In the 1870s, 1883, I might be off by a year, but I think in 1883 the Supreme Court decided a case called the Civil Rights Cases. You'll read it. It's in your book. We'll read it later this semester. Called the Civil Rights Cases. Congress had enacted a law in the 1870s which prohibited discrimination on the basis of race in certain places of public accommodation, hotels, inns, restaurants, theaters, etc. The Supreme Court said that law was unconstitutional. Again, Congress didn't enact a civil rights law that passed muster until the 1960s. But in 1875, just check me on the year, I think it's 75, Congress enacted the Civil Rights Act. And this law said you can't discriminate in these places. The Supreme Court said, no, Congress, you don't have the power to enact this legislation because it's not state discrimination. It's discrimination by private parties. This case, the Civil Rights case, established what came to be known as the State Action Doctrine. The State Action Doctrine. Okay, what's the State Action Doctrine? Congress can only regulate under the 14th Amendment state action, that is action by the states. If the state discriminates on the basis of race, then Congress can intervene. But Congress cannot regulate private businesses under the 14th Amendment. All right. Now, the 14th Amendment didn't actually help much for states either, because a couple years after the Civil Rights case was decided, the court decided Plessy versus Ferguson, which held that separate train cars were permissible so long as the accommodations were equal. So in those decisions, the court basically gutted the 14th Amendment's Equal Protection Clause, just gutted it altogether. But the doctrine to this day stands. To this day, the court says that this provision only affects state actors, does not affect private businesses. Therefore, in 1964, when Congress enacted the Civil Rights Act, they cited the Section 5 stuff Justice Douglas talks about a little bit in his opinion, but they primarily looked to the New Deal precedents. And they relied on Wickard. They relied on Darby. And they relied on Jones and Laughlin Steel. Right? So our modern civil rights laws are not premised on the Reconstruction Amendments. Our modern civil rights laws are premised on the Commerce Clause. And this always makes students feel a little bit awkward. If you read Heart of Atlanta carefully, it basically analogizes people to commerce. That people are traveling to their commerce, therefore you can get rid of discrimination. It's a bit like, I always have this feeling like, that's a little weird, right? That seems off. That the way you uphold civil rights laws is by comparing people to commercial transactions. It's just, you might like the result, fine, but it always feels a little off to me whenever I teach this case. Okie doke. All right, so any questions about that? We'll do the 14th Amendment in the second half of the semester, which might be like in 2 weeks or something because we go so quick. So any questions on this? No? All right, who's next? Chelsea? All right, you want to give me the facts, please, in the first case, Heart of Atlanta Motel via United States?
So the hotel in Atlanta did not allow African Americans to stay there.
Mm-hmm.
But it was easily accessible to multiple interstates, and they were advertised nationally, and the
Very good. Okay, very good. All right, so we have the Heart of Atlanta Motel. This is a crazy story. Do I have the, okay, so there's a picture, I don't have it here, but there's a famous picture of the Heart of Atlanta Motel where there's a swimming pool. And there's actually a little boat they put inside the swimming pool as a commercial for it. And there's just this girl inside, just like a pageant, whatever. And so I always showed this picture in class of this boat inside the swimming pool with this woman inside. And said, you know, here was a commercial for this hotel. And a couple of years ago, one student sitting right around there said, oh my God. And she recognized the photo. It was her aunt. The aunt was a pageant winner and had just taken a picture in a boat inside a swimming pool. And that picture was in her home, and she never knew what the hell it was. It was her aunt being a promo girl for the Heart of Atlanta Motel. Isn't that nuts? It's insane. Oh, totally random. I met a guy a couple months ago. His last name was Philbrun, F-I-L-L-B-R-U-N. He's like, oh yeah, you know, my name's really similar to Roscoe Philbrun. I'm like, well, guess what? His name was actually Philbrun, but he changed it from anti-Germanic sentiment. So they were actually related. And like I connected him. He's like, because he's from Ohio, from the same region. He's like, yeah. So like there's something like this constitutional like matchmaker of some bizarre universe. I don't know. It's like, you know, swiping right. Okay. All right. So we have here the hotel, right? Now, just be very precise. The hotel had a racial exclusionary policy, right? They would not rent African American patrons, right? Was that activity itself, the decision to not rent a room to a black patron, was that activity commerce, interstate commerce? It was not. Okay, just be very careful about this, right? The actual act of excluding African American patrons from the business was not interstate commerce. But here, the fact that such a hotel existed did obstruct interstate commerce. Why? 3/4 of the guests were from out of state. If you were driving from, say, New York to Florida and you wanted to make a pit stop in Georgia somewhere, and you came across this hotel and they said, sorry, we won't rent you a room, that would obstruct the flow of interstate commerce, right? Because you couldn't do what you wanted to. You have to keep driving. So the key fact here, the local activity of denying service to these customers, when taken in the aggregate, had a substantial and harmful effect in interstate commerce. Okay? So here we have a situation where it's basically Commerce Clause and Necessary and Proper Clause. Let me explain what I mean by that. The moving of people from state A to state B is itself interstate commerce. And this hotel could obstruct that interstate commerce. But even if it didn't, the local activity could then have a substantial effect in interstate commerce in the aggregate, right? It's both. I want you to see this, right? And in this regard, EC Knight is still kind of good law, right? Here there's an actual obstruction in interstate commerce. It's a hotel that advertises and solicits out-of-state customers, and they're saying, you can't stay here, right? People driving from one state to the other now have no hotel to stay in. So Commerce Clause, check. We also have Necessary and Proper Clause, right? Because in the aggregate, local discriminatory policies will substantially affect interstate commerce. That makes sense? Yeah, Audrey?
So whenever we think of the aggregate,
yeah,
we apply it to the necessary.
Yes, ma'am. Yes, ma'am. Okay. And here the court actually applies the means and scrutiny very openly. The court says whatever means to be employed is within the sound discretion of Congress. Right? We're not going to scrutinize the means. The court says, so long as the means chosen are reasonably adapted to the end permitted by the Constitution, we're fine. Right? As long as there's some fit between prohibiting racial discrimination and ensuring people can travel safely from one state to another, the courts will not intervene. And here the court cites McCulloch, or at least it follows from McCulloch. It's a Necessary and Proper Clause case. Okay. So here you have necessary and proper and commerce. You have both of them working in tandem. Okay. Any questions in Heart of Atlanta? I think it's a Hilton now. I'm not sure, but I think it's a Hilton hotel. I think it's the Atlanta downtown Hilton. Anything? Any other questions in Heart of Atlanta? All right. I think Tyler, are you next?
Sure, yes, sir.
Okay, let's do the second case, Katzenbach v. McCulloch. What are the facts in Katzenbach, please?
Ollie's Barbecue. So it was the parties, the owner of Ollie's Barbecue eating establishment, and the Attorney General of the United States. It's a place in Birmingham that refused to serve African American customers.
They were allowed to work there, though.
Sir?
They were allowed to work there. So they actually had African American waiters and waitresses who wouldn't serve them. It was pretty bad. Yeah.
The government wanted to enjoin, to prevent that discriminatory act based on interstate commerce. That barbecue establishment, it's not like the Heart of Atlanta that had all of these proximate connections. It was removed.
Yeah. Do they service any out-of-state customers?
Correct.
No, no one's going there from out of state. It was a hole in the wall in Birmingham, right? So the court found that they did not serve out-of-state customers. So there's no standalone Commerce Clause authority here, right? But Fabian, what about the necessary and proper clause?
So how does the necessary and proper clause fit in here?
Yes.
It's implied, the implied powers, is that what we're talking about?
Well, what's the test under the necessary and proper clause? What's the test we have?
Ends and means.
What case are we talking about here?
We're talking about specifically?
Well,
or
what's the leading case which we talked about today for necessary and proper clause? What case does it come from?
McCulloch?
Well, there's McCulloch, good, but a little more recent. Which case from the New Deal gave the broadest reading of federal power?
Darby?
No.
Is it NLRB?
No, you're going the wrong way.
Segregation.
Wickard?
And what was the test from Wickard?
The substantial effects test?
Very good. So consider the substantial effects test in the context of Katzenbach.
Oh, okay, so, Congress should have power in this sense?
Why can Congress regulate the local restaurant? What about this local activity? Why then can Congress regulate it?
Because the effect is great even though it's not.
The effect of what? You're almost there.
The effect of the power, I don't know.
I just want to say to you, because we're almost done, you're really close. When we say we're aggregating, what are we actually aggregating? What are we adding up?
The instances?
Instances of what?
Discrimination, I guess?
Okay. So because this local restaurant discriminates,
Yeah.
finish the sentence, right? So we know this local restaurant discriminates.
We can aggregate
Aggregate what?
the substantial effects?
No. What are we aggregating? So we have one restaurant here, Ollie's Barbecue. It's engaging in racial discrimination.
Yes.
Then what are we aggregating? What are we adding up?
People, if they serve.
No, I'm leaving. You're almost there. I want you to get this, right? Okay, so let's talk about Wickard for a minute, right?
Okay.
We had one farmer growing wheat by himself, right?
Yeah.
What then do we aggregate? What then are we adding up?
In that case, we were adding up all the other farmers. who
Very
were doing
good.
the same thing.
Okay, good. So now apply it to the Katzenbach case. So you have one restaurant that's having a
All
racial.
of the restaurants.
Bingo. And if all of these restaurants have a racial exclusionary policy, then
Then we can aggregate.
Uh-huh.
And it becomes a substantial effect.
On? substantial effect on.
Interstate commerce.
Bingo. Now you're done. Okay, very good. Okay. you have one restaurant that has a racial exclusionary policy, no big deal, right? It doesn't have a big effect. But if you aggregate all these little hole in the walls in Birmingham, call it Jim Crow if you will, and if you aggregate them all up, then you're sure as hell going to have a substantial effect in interstate commerce. Because at some point, someone will be coming through from another state and won't be able to eat there. Now, the court actually uses a different argument, right? The court says that a substantial portion of the food served in the restaurant had moved into interstate commerce. Now, why don't you just focus on that, right? They're not even talking about aggregating racist policies. They're saying that the food they served came from out of state. But the law at issue isn't regulating the food being served. It's regulating whether you exclude people. This is even more, right? Katzenbach actually expanded beyond Wickard. Instead of aggregating the actual activity that's being regulated, segregation, for example, you now aggregate something else, right? You now aggregate the food that the people in the restaurant would otherwise eat. So in this regard, Katzenbach went beyond Wickard, right? Katzenbach went beyond Wickard. So long as something you do has some sort of connection to interstate commerce, then Congress can then regulate it. This is what's called a jurisdictional hook. H-O-O-K, think of like Captain Hook, right? It's something to latch on to your case. Something in your store traveled in interstate commerce. Right? Something in your store traveled in interstate commerce. Doesn't matter what it is, food, whatever else. By the way, I have a collection in my office if you want to come see it. I actually found a matchbook from Ollie's Barbecue that was manufactured in Georgia. So I have proof that Ollie's Barbecue had matchbooks that were manufactured out of state. So the jurisdictional hook is satisfied.
So is there still the 1% limitation?
It's getting close to 0.1% at this point, right? It's like maybe 0.5, like 99.5%, right? So long as you have a jurisdictional hook, right, that there's some local activity, utilize an item that traveled in interstate commerce, maybe a tool, maybe an oven, maybe ingredients, then Congress can regulate it. Yes, of course.
So where is the stop to this?
Oh, we'll do that one next week, I think, and maybe the week after.
Lopez?
We'll get there a little bit, right? But I'll give you a preview, right? In all these cases we've done today, we've talked about some sort of economic activity, running a restaurant, running a hotel, lumber, right? But what if the activity is not economic? Right? Lopez drew the line between economic and non-economic activity. For example, possessing a gun in a school zone was deemed activity that's not economic. Therefore, you cannot aggregate non-economic activity. Lopez said you can only aggregate economic activity, like growing wheat or running a restaurant or running a hotel. Right? That was the sort of, Lopez drew a line in the sand. But so long as you have a jurisdictional hook and the government can show that their activity has some sort of connection to interstate commerce, there's not much of a line. Indeed, this is Randy's phrase. I'm not a fan of it, but he likes it. That's called the herpes theory of jurisdiction. Right? Once an item travels in interstate commerce, it forever retains that trait. Can't get rid of the herp. You can't. Yeah. Randy once put in the book. I was like, okay, fine. I think he read that line, or no, maybe I did. I think I did in the video. Yeah. Anyway, but after after Ollie's Barbecue case, Katzenbach, so long as the government can show there was some hook to interstate commerce, then the court will uphold it. So just think of how far we've come from our, question at the beginning of class, right? We start in Prigg, which was a fairly broad reading. We have DeWitt, which then says, no, the government can't regulate that which is local. E.C. Knight basically reflects DeWitt and has his direct versus indirect effect test. Champion, some of an outlier. Then we have Schechter Poultry, which brings back the direct effect test. But Jones and Laughlin Steele, Darby, and then Wickard employ the substantial effects test with aggregation. And then when you have substantial effects test plus aggregation plus jurisdictional hook in Katzenbach, there's very little Congress can't do, right? When you have the jurisdictional hook you have substantial effect, you have aggregation. When you have those doctrines all working in tandem, the sky is the limit for the federal government. Yes?
So with the jurisdictional hook, like, the Katzenbach case, couldn't that again be another really trying to protect something else? Because to
Yep.
me, it does seem like it's a little far-fetched to be like, oh, something, a piece of paper was
Yeah.
in Georgia, like, so.
It's a stretch, yeah. I mean, it's Justice Chase wrote if it's too remote, right? But once you have the jurisdictional hook, remote's okay. Indirect's okay. It can be a very far off thing, right? The New Deal courts and then the Warren courts are basically premised on the notion that the court should not scrutinize when the federal government exercises power. That if some act of Congress passed through all the Democratic branches, at that point, it's not for the court to second guess.
Would one interpretation of the limiting power in this case be like in some respects to protect like civil rights? Like, I guess to me when I look at this case, I'm like, oh, it makes a little more sense because it's like discrimination versus when I look at like trying to invade on a state's power to regulate like wages or something.
Well, it's one and the same because, I mean, again, I sort of referenced this point earlier, but Heart of Atlanta always gives me a little bit of a weird taste in my mouth because it's basically saying that people traveling are commerce. It basically describes a person as an article of commerce, right? And that's just, it's weird, right? We'll do the 14th Amendment later this semester, but I think what you'll find is that the decision of the courts in the 1800s to read the 14th Amendment narrowly led Congress to then go rely on a broad reach of the commerce power. In other words, because the Supreme Court in the 1890s read the 14th Amendment so strictly, Congress had to improvise and use the 14th Amendment. So I think much of what Congress does today for federal anti-discrimination laws are better understood as actually civil rights laws under the 14th Amendment, although the court didn't say that. Justice Douglas, you read his little concurring opinion, would have said so directly. Okay. Okay. Any other questions on today's reading? Okay. For tomorrow, we'll be reading the Rehnquist court cases. Lopez, Morrison. I think we do Raich as well, right? I can never. This class moves so quickly, one day at a time. Yeah, we do Lopez, Morrison, and Raich. Oh, and also we do South Dakota v. Dole, very good spending clause case. Any other questions? All right, we'll see you tomorrow night. Have a good night. Thank you.